Good morning.
Morning, Your Honor.
Good morning, Your Honor.
Good morning. Well, welcome to the First District Court of Appeals. And today we have one case scheduled for oral argument. That is case number C200264, State of Ohio versus Christopher Hall. If each side can please identify themselves and their readiness to proceed.
I'm David Hoffman. I represent the appellant, and I'm ready to proceed, Your Honor.
Good morning, Attorney Hoffman.
I'm Amber Daniel. I represent the appellee, and I am also ready to proceed.
Good morning, Attorney Daniel. Attorney Hoffman, would you like to reserve time?
5 minutes, please, Your Honor.
All right. Whenever you're ready, you can proceed.
Thank you. This morning, I only wanted to discuss the self-defense argument in the brief. And the reason why I asked for this hearing is that it might be the way I read it, but the State versus Parrish from this court appeared to me to continue after the new law in 2019 require a burden of persuasion on the part of the proponent of the self-defense defense. And I thought it was pretty clear that it only requires the burden of production, that without any kind of level of persuasive value. In other words, it would be similar to a sufficiency challenge or defending against a sufficiency challenge on appeal. You'd simply use the proponent's facts surrounding the self-defense claim and see if those facts would meet the elements of self-defense. And if they do, then the burden would shift to the state, who'd have to prove beyond a reasonable doubt that the defense doesn't apply. And I think that the statute makes it pretty clear that that's the way it works. In paragraph A of the self-defense statute, of the affirmative defense statute, it says that the burden of proof by preponderance of the evidence for an affirmative defense other than self-defense is upon the accused. So they take self-defense out of that requirement for preponderance. And there are cases I cited in the additional authorities that I filed that also say that preponderance is no longer required. And there are some things that follow from that, because if you're looking at whether the prima facie case has been met by the proponent of this defense, you'd have to use his facts or the defendant's facts. And so that makes a big difference.
How are you saying the judge did not do that in this case? Are you saying that the trial judge, who was the finder of fact, did not do that in this case? Because it looked to me like this was just a he said, she said kind of case.
It was like that. And so credibility did factor into this. But I think the analysis to review the judgment has to follow the format that I'm about to go over, because it's important on which self-defense test to apply. I mean, is this going to be did he use lethal force? Did he try to strangle this woman and cut off her breathing, or did he push her and block her slashes? And so it's important as to which test for self-defense you're going to use to review this judgment. And so logically, you would use the test that I proposed in my brief, because a sufficiency standard would have to do with the facts, only the proponent's facts, to see a prima facie case. You wouldn't use Ms. Smith's facts to determine if my client put on enough evidence to establish self-defense. It's just logically you wouldn't do it. You'd have to look at what he put forward to see if he met the standard of production. And so that will lead you to the test for non-lethal force. And so then after that, you meet that first step, then you'd look at credibility and you'd see if the state disproved that beyond a reasonable doubt.
And how are you saying they didn't?
Well, I'm glad you asked that. There's a lot of things that have to do with credibility that really detracted from Miss Smith's credibility. She testified she allowed herself to be beaten, which is unusual. It was shown at trial that she lied about the presence of Mr. Hall immediately after the event. Her scenario of how this fight started involved a triggering event it was just less of an event to cause a fight. Her injuries didn't match her story, and she has a prior record of violent offenses. All these things detract from her credibility that would and add to my client's credibility. I think his story stuck. He had no contradiction in his story. All the traditional tests for credibility are in favor of my client. That's why I think
didn't the photographs kind of bolster her credibility? I mean, it seemed to me that the prosecution kind of relied on those photos to say you need to believe her version of the events over your client's. And the judge even commented about the photos at the sentencing hearing. So, I mean, it's a credibility determination. And how do we overturn that?
Well, I looked at the photographs, and the bruises don't match the way she said this thing went down. I mean, it's as simple as that. She had bruises and she's hurt, but I think if you examine them closely, compare them with her testimony, they don't match up.
How
And
so?
that's why I think the photographs don't really help her.
How? I mean, can you explain to us how the photographs don't help her?
Well, she said that her breathing was cut off on her neck. And she couldn't say whether he held her with two hands or one hand on her neck. She only has a bruise on one side of her neck, and it doesn't look like a handprint. That's one thing. That's just one thing that I'm able to come up with, but it contradicted her story. And so that's why I think it doesn't help her credibility.
Let me ask you, Mr. Hoffman, are you abandoning the issue, the discovery issue in the motion to eliminate?
Certainly not, Your Honor. It's just that this is what I wanted to focus on because I wasn't sure about what this court was saying in Parrish. I didn't expect you to tell me, but I wanted to put forth my position on it about the standard of the burden of production, and then how the analysis follows from that recognition that it's a burden of production and not a burden of persuasion. And so it determines which test you use for self-defense. And so that's the point I wanted to make. And so if there are no further questions, I'd ask that the court reverse on both assignments of error.
I just have a question about, I'd like you to address that discovery issue if you could.
Certainly. Well, the first thing that comes to mind is Miss Smith's Tammy Smith's testimony that there were cameras at her apartment complex. Sometimes the city owns these cameras, sometimes they're privately owned, and the record doesn't say which is which. So it might have been a privately owned camera, but this court has in the past been faced with the question of whether a discovery demand applies to evidence that's in the hands of a private actor. And I think that issue is present in this case, and I think it should apply because
there's no information that there was any video from the cameras, right?
I'm sorry, Judge, I didn't hear the first part.
You're talking about the cameras on the apartment complex?
That's correct.
I thought the prosecution didn't even know if there was any video. The police didn't check that. That's exactly right. They didn't check it. So he wasn't able to say whether there were cameras or not. But Tammy Smith was very adamant about the fact that there were cameras, that this thing happened right in front of a camera. And she tried to bolster her credibility by saying that the camera caught everything. And that's the unfairness that I was trying to bring out there. And so there was testimony that evidence at once existed,
Attorney,
but it wasn't produced at trial. And so that's the problem. And that happened in another area too, the body camera.
Hoffman?
Oh, yes, Your Honor.
I guess ultimately, and I think this is Judge Krause's point, is the only thing we have is Ms. Smith's talking about the cameras, but we don't have anything further to know whether there actually were cameras or not. So how do we get to the duty with any duty involving those cameras if we don't know whether those cameras actually existed? And then whether there was even footage with regard to those cameras?
Well, Your Honor, it's kind of circular. I mean, she testified that they did exist. She testified that they caught everything. And now I mean, you can't prove a negative. You can't really prove that. I don't know how you could prove that they once existed but don't exist anymore when they're not produced at trial. I think that's all you have to show. You have to have evidence that this evidence once existed, but it wasn't produced despite a demand. And I think that meets the test.
What about the photographs? You talked about the photographs in your brief with regard to the discovery violations.
Yeah, there were photographs. There were color photographs, 8.5 by 11, and they depicted bruises on Miss Smith. And there was a previous discovery response by the state indicating there was no evidence. It was never supplemented or anything. And then they showed up the day of trial and disclosed this to defense counsel the day of trial. And so I think that's a problem. And I think that it was kind of mishandled at the trial on the sanction level too, because asking for a least restrictive sanction is not an explanation for the non-disclosure. I mean, it's a request for the least restrictive sanction, but that wasn't what needed to be said. I mean, the prosecutor needed to explain the late disclosure, and it was never explained. And so the trial court had nothing except a written discovery response saying they don't have anything, and then disclosure the date of trial. And excuse me, getting a dry mouth, I need to take a drink. As I pointed out in the brief, it had some tactical consequences. It was difficult to deal with the evidence when it was disclosed at that late time. There were a lot of things that could have been done. There could have been an examination of alternate causes for the bruises. There could have been
a continuance was offered, right?
Well, that's another thing, Judge, that my client was incarcerated pre-trial. He wasn't able to be bonded out. And so a continuance would have just extended his pre-trial detention. And that
wasn't he incarcerated on another charge though? I thought he had an OR bond on this one, but then he was incarcerated for a protection order case.
Well, if that's true, that would change my argument. And I'm not able to address that.
How would that change your argument if he were not incarcerated, if he had an OR bond on this case?
Well, let's see. If he's being held on another case, I don't think he might not get the credit against his sentence for being held because he had an OR bond and he could have been released. And so I guess that, it depends. It could cut both ways, I guess. If he's held longer, but he's never going to get credit for it, that could be a detriment to him too. So I'm not really sure how it could. I think it could cut both ways, actually.
You mean like a speedy trial issue?
No. I mean, he's not going to get credit pre-trial. He shouldn't get pre-trial credit for being held prior to trial if he's being held on another charge. If he has an OR bond on this case, I don't think that the charges in this case, this was just a domestic violence case. This wasn't a TPO violation, I don't think. It was just domestic violence. And so if he's being held on a bond for a violation of a TPO before this trial, he shouldn't get credit against his 45 days that he got here based upon being held before trial. And so if you extend it out, he's never going to get the benefit of being held. I mean, he's never going to get a credit. And so it might be worse for him that might be why he didn't want to get a continuance. I don't know. So it doesn't necessarily mean that it doesn't necessarily ruin my argument that he's being held on another charge, I don't think.
Thank you for your argument. We'll reserve your time.
Thank you, Your Honor.
Attorney Daniel, good morning again.
Good morning. May it please the court. My name is Amber Daniel, and I am representing the appellee of the city of Cincinnati today. I will first discuss the self-defense argument. As stated in my brief, the tests that we are looking at are the elements that, number one, if he was going to use self-defense, that he was not at fault in creating the violent situation. Number two, he had a bona fide belief that he was in imminent danger of death or great bodily harm, and that his only means of escape was the force that was used. Number three, that he did not violate the duty to retreat to avoid danger. That is the test that we would be looking at if he even met the burden that it would switch to our persuasion. We believe that there's no evidence at this time or at court to show that he had self-defense aside from his testimony. We believe that the evidence at the trial court showed that it was not a self-defense issue at that time. Based on Ms. Smith's testimony, Ms. Smith testified that she did not lay hands on Mr. Hall, that she did not shove him, she did not push him, that she was afraid herself that if she did one of these things, that she could go back to jail at that time, which would describe and explain why she did not want to defend herself. So we believe that this would not even be a self-defense situation, as him pushing her to the ground and choking her happened based on a incident of her not purchasing marijuana for him, which would not rise to the level of him needing to use any kind of defense against her. He also stated that until she allegedly pulled a knife out on him, which she says that she did not do, until she allegedly did that, he is stating that he was not afraid of her. So he was not afraid of her when he pushed her down, and he was not afraid of her when he choked her.
So you're stating he didn't meet his initial burden?
Yes, Your Honor, that is what
Okay.
I'm stating. But if you do believe that he did meet his initial burden, once we get to the elements, I believe that we have proved beyond a reasonable doubt the first element, that he was at fault for creating this violent situation. As Ms. Smith stated, that she did not hit him, she did not push him, she did not put her hands in his face or do anything to him before he pushed her to the ground and choked her. At that time, there would be nothing for him to defend. So he would have been at fault in creating this situation, as he is the one that used the physical contact to start with. It was not her. So that is the first element of self-defense, that we believe that at the trial court, we met the burden to prove that there was no self-defense, and we believe that we have proved that beyond a reasonable doubt. Moving on to the discovery violations portion. A continuance was offered on the day of trial for the photographs. The defense counsel could have taken the continuance at that time, and not taking the continuance at that time, we believe constitutes as a waiver of that argument, as they could have had a reasonable time to prepare the case with the photographs.
But there was no inquiry into the reason for the discovery violation. I mean, the evidence at trial showed that this police officer showed up and took photographs of these injuries. So presumably the prosecution had these photos. And there was no inquiry into why they weren't turned over. And I ask you, is that, under our case law, is that not an abuse of discretion to fail to inquire?
Your Honor, it is my understanding that we did not get the photographs until the day of the trial, and the police officer did not provide the photographs until the day of the trial. So we would argue that that would not be a violation, as we did not have the photographs until the day of the trial.
You can't hide behind that, because I mean, the police and the prosecution are kind of one and the same when you look at this, right? So it would be the prosecution's duty to inquire. I mean, it's a domestic violence case, and probably the best evidence that you have, especially when you're dealing with a he said, she said situation, is photographs, right, of the injuries. So my only question, though, because there was no inquiry by the judge, there was no explanation given on the record, is that in and of itself an abuse of discretion?
Your Honor, I do not believe that that would be an abuse of discretion. I cannot speak to everything that was done by the prior prosecutor at the trial level, as I'm not sure the inquiries that she did or did not do before the trial, but I do not believe that that is abuse of discretion. I believe that the means should have been a continuance at that time if they wanted to get a continuance, and that is my belief on it. Moving to the next issue, which was the body worn camera issue. That issue was presented at trial. It was not presented before trial as to if the defense counsel wanted to compel the body worn camera or anything along those lines. Body worn camera was never presented by the state at trial. We did not intend to use it at trial. We did not have it prior to trial. A motion in limine was re-brought up after the body worn camera came and body worn camera was added into it. Our argument to that is that we did not present body worn camera. There was no continuance to get body worn camera, so that would be a moot point and a waiver of the body worn camera issue at that time, as we did not have body worn camera yet, and it does take about a month to get body worn camera from CPD records. So if we would have gotten a continuance, we would have been able to get body worn camera to the defense attorney at that time. And on the third and last point is the surveillance camera point. That issue was not presented at court, so it was not raised at trial. There was testimony as to if there was or if there wasn't, but nothing was presented at trial as to an objection to using it, an objection to not having it, anything along those issues. So this would be a new issue that was presented in the brief. So we believe that that cannot be argued and cannot be looked at this time. There's no evidence to show that we had that video. There's no evidence to show that that video even existed. So at this point, if there are no further questions, I would rest on my brief.
Thank you. Attorney Hoffman?
May it please the court. I just want to reiterate on the self-defense part, again, how important it is to realize that the burden of production being on the proponent determines which test for self-defense you're going to use. It really does logically do that. That burden is on the proponent of the evidence, and his facts have to be used to determine whether the elements of the particular self-defense have been met. And if his scenario fulfills the test for the non-lethal self-defense, that's the test you got to use.
But then the burden then shifts to the prosecutor, right?
Right.
And so how, I guess my question is, this was a bench trial. And how are we able, I mean, this is a credibility issue. How are we able to determine if the judge didn't look at this properly? I mean, I get it in a jury trial situation. Maybe if you don't get the instruction, or if the judge says that you didn't, do your production to get a jury instruction. But I'm just trying to understand, in a case like this, when it's a credibility determination, how are we? That's what it comes down to, right? And we presume that the judge said, okay, I properly did the burden shifting, and the prosecution proved beyond a reasonable doubt that there was not self-defense, right?
Well, this is important because it's got to be a two-step process. The first step has to be that burden of production. And I'm very familiar with it, because when I was a prosecutor, you'd write all these briefs about, and you'd defend against the sufficiency claim. And it gets to be a second nature. They claim the evidence is not sufficient. And so what do? You look at this, in the light most favorable to the state, you look and see if those elements were met again and again and again. And you don't look at the credibility at all. You just look at if those things were met.
Well, what if we agree they were met, and then the burden shifted?
Right.
And then what do we do on a bench trial, manifest weight issue?
Then you look at credibility, but you look at credibility with respect to those elements for the test that applies to the proponent's facts. And you see if those proponent's facts are proven or disproven beyond a reasonable doubt. And what do? You use the traditional tests for credibility, just like this court does all the time in a manifest weight case. And you see who was lying. Who lied in this case? Tammy Smith lied. If she was shown to be a liar, she lied about my client's presence. The police officer, basically it was like night and day. And you've got that. And you use that to determine credibility. You don't use her facts.
You use my client's facts and see if they've been proven or disproven by the prosecutor beyond a reasonable doubt. You got to do it on your own. The trial court's not going to spell it out. So that's my answer. The other things that were pointed out with regard to discovery, let's see. I'm not sure about the time, but anyway, the
We
discovery.
have a couple minutes.
Thank you, Your Honor. The discovery, the evidence that once existed that was not produced at trial became apparent at trial. They couldn't have been subject to pretrial motions. They couldn't have been even contemporaneous objections even. After the officer testified, these issues were pointed out, and that was timely. I think these issues were preserved by defense counsel. And so that's what I wanted to point out. The body-worn camera footage is gone. I think you have to ask for that within a certain amount of time, and they recycle it. I don't think they keep that stuff. And so I think a continuance of the trial to obtain body-worn camera footage would have been ineffective. So that's all I have to contribute. I'd ask that the court would reverse this judgment and either discharge or send it back to the trial court for further proceedings, if there are no further questions. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision, and we wish you both a wonderful afternoon. That concludes oral arguments for today.